Hello, my name is James Fagan and I am a new tenant at Radcliffe Chambers, having recently completed my pupillage in December 2020. Today I'll be answering the question about what was my most interesting experience in pupillage. It is hard to choose from many of the interesting cases that I've assisted my supervisors and other members of Chambers in, as well as those I've worked on myself. However, I think my most interesting experience is a case I worked on during my second six. This was an application for a rescission order of a winding up. These type of applications are provided for pursuant to Rule 12.59 of the Insolvency Rules 2016 and are quite difficult to make out successfully. The jurisdiction is successful and the test boils down to whether the circumstances involve a material difference from those before the court at the time the petition was being heard. Additionally, any application made out of time must seek an extension of time under the principles in Denton, which are likely to be familiar to those of you on the GDL or BPTC. My client was a director of a company that was wound up following a petition by its landlord. When the case came to me, the petition being advanced was a failure to properly serve the company with the petition, resulting in no appearance being made by the company to defend against the petition. Had the company known, it would have sought an adjournment and paid off its debts as it was not insolvent. However, this argument would face an uphill battle, so it was decided to advance our case on the basis that this was a rare case where exceptionally the creditors would be in a better position if the rescission was granted, as they could all be put into funds. This would avoid difficulties in attempting to disprove service having taken place. I had to work closely with my solicitor to work out the evidence that was needed from the client and whether additional information was required once we'd received answers. At the hearing, it became apparent that the liquidators had concerns that their fees wouldn't be paid. In particular, an argument arose as to whether the court would have jurisdiction to restrict liquidators' fees on the ground of reasonableness. The suggestion by the judge to adjourn the hearing as part heard to allow for further evidence of solvency to be obtained was accepted, and the case was adjourned until November. Ultimately, this allowed further time to make the necessary inquiries with financiers and reach final agreements with various parties, including the liquidators. The relisted hearing date came, and I was successful in persuading the judge to exercise her discretion. So, why was this case the most interesting experience for me during pupillage? Well, first, it showed me the importance of taking a pragmatic approach to disputes and being clear with your client about their prospects. The initial case tactics faced difficulties and risked the judge dismissing the case rather quickly. In contrast, there was a practical solution that required advancing the case with a different emphasis, one that ultimately succeeded. I learned that a good barrister needs to work as part of a team to determine the best approach for a given case, even if that requires walking back the current strategy. Secondly, I learned a considerable amount about insolvency law and procedure during this case. The learning experience that comes from getting into the detail of live cases is second to none. In particular, I had to get on top of principles surrounding control of insolvency office holders and formulate arguments that drew not only from corporate insolvency law, but from personal bankruptcy case law and general civil procedure. And finally, it required me to build on all of my learning experiences today. During the course of pupillage, I had the opportunity to conduct research, draft skeleton arguments, and observe my supervisors and other members of Chambers in conference and in discussion with counsel for the opposing side. Being able to reflect on the different approaches I saw, learn from them, and deploy aspects of them myself was incredibly fulfilling. It also helps to know that members of Chambers are always happy to provide a sounding board for ideas whenever I got stuck on a given point.